Okay, thank you very much. Good afternoon, everyone, college, speaker, presenters. And well, today we are now in the 5th sessions before the end of the 6 sessions. I hope you still bear with us today. Now, I have the honor to chair these sessions, and I think this is very special session then because you put me with my other colleagues from Indonesia. So this is very Indonesian perspective. Now, as we understand and well aware that the ESG is now becoming a huge or a phenomenon in the, I think in the contemporary discussions of company law. Why? Because we are facing these contemporary issues of global climate change and also social inequalities. So there is this market demands that corporations or company should also be addressed these non-economic concerns. Now, the question remains is that to what extent the company or at least the company law should accommodate this, what I call as a paradigm shift, yeah, to integrate the ESGs within the operational or the actions of the company itself. Now, perhaps there is similarities or differences in approaching the ESG within or across jurisdictions, particularly in Asian and also now in Indonesia and also perhaps from the Australia perspective. I think we have with us now from the Indonesia in the sessions of looking into challenges and opportunities of Indonesia environmental, social and governance legislations and lessons learned from Asian collaborations. So we have here from our college is from the Gadjah Mada universities, Professor Laurensia, Professor Dina, Kariodimedjo, because I used to call her Dina, sorry, and also Professor Irna Nurhayati. And then you have like 15 minutes as previous sessions to present your paper and will be followed by Professor Vivien Chen from Monash University. And then we are going to have the Q&A. I think now I give the floor to the presenters.
Thank you, Professor Yetty. Good afternoon, everybody. Please call me Dina. And here are my colleagues, Laurensia and Irna. So we are from the Faculty of Law, Gadjah Mada University of Indonesia in Yogyakarta City. So it's a great honor to be here at the ACLF 2025 to deliver and to share our research title looking into challenges and opportunities of Indonesia ESG legislations and lesson learned from Asian collaborations. So as we knew that the 1987 Brundtland report of Our Common Future introduced the CSR concept on sustainable development and Earth's business to adopt social and environmental responsibility. Next, please. The principle of responsibility investment introduced the ESG, which emphasizing its dual benefit for society and businesses, and the practices of ESG, which emphasizing its dual benefits for society and businesses, and the practices of ESG are linked to global initiatives such as a Paris Agreement, which is focusing on reducing risks and also leveraging opportunities in environmental, social, and governance areas. So this paper discusses Indonesia's ESG framework on its significant carbon emissions from land use changes and deforestation, and also Indonesia's natural resources. And the paper also analyzes Indonesia's unique approach of mandatory CSR for natural resources-based industries. So further, experience of Singapore and Japan as countries which aligned with international ESG standards compared to examine Indonesia's regulatory framework for fostering sustainability. So from this slide, we can see Indonesia's ESG regulatory framework. So the first is Presidential Regulation of 2017, amended by Presidential Regulation 2022 on sustainable development. So this is like a general regulation related to sustainable development in Indonesia. And the second one is several laws and government regulation aligned with the ESG principles, such as 2009 Environment Act, and then 2007 Company Act, 2025 State-Owned Enterprises Act, and 2003 Labor Act, and also government regulation 2012 on social and environment responsibility for LLCs. So we have also a specific regulation on ESG, on reporting and sustainable finance, so such as Financial Services Authority Regulation, so we call it POJK, of 2017, and also OJK Circular Letter 2021. So we would like to focus on the last two specific regulations. Here, the POJK 2017 and also the OJK Circular Letter 2021. So first, the party regulated or the subject regulated in the regulations are only financial services institutions, issuers, and also public companies. So this parallels with the authority of the OJK to perform an integrated regulatory and supervisory function for all activities in the financial services sectors in Indonesia. However, it covers only a small portion, about 0.1% of the total number of business entities in Indonesia. So this invites for the government attention to create regulation that can reach a wider range of business entities in Indonesia. Further, the regulation allows financial services to allocate a portion of their CSR fund to implement ESG. So we think that this stipulation indicates a failure in understanding differences between CSR and ESG. CSR is basically running program externally or outside the company approach to ethical business practices. And this is distinguished from ESG, which is implementing the principle of ESG in the internal governance of the company, ensuring and reporting company performance on ESG factors, especially to assess the company's sustainability. So Laurensia will continue, please.
Okay, thank you. So based on the problems that my colleague has iterated, which are about the subjects of, next slide. Okay, about the subjects of the ESG's reporting in Indonesia, and then also with regards to what are the incentives from the government, which we assume that it is less appetizing when we compare to other countries in Asia, and also with regards to how Indonesian failed to distinguish between ESG and CSR. So based on those three elements are what we are going to find in our comparative study. Next, with regards to Singapore, and there are two legal bases for that. So in the obligations in Singapore is for, or the subjects are all listed companies, and they have to perform 5 components, like for example, material ESG, climate-related reporting, and policy practices and performance, and etc. So in Singapore, they are obliging or mandating the listed companies to report their ESGs. And there is also a plan in 2027 that they will mandate non-listed companies at a certain level of assets, like 1 billion Singaporean dollar asset. Next, please. Okay, so 3 aspects that we are comparing our Indonesian regulations on ESG and also in Singapore. The first one is with regards to subjects, which I have mentioned previously, and then the second one is with regards to incentive. So we thought that Singapore gives more appetizing incentive for listed companies to comply with the ESG reporting, because it gives a grant with a cap of 1 billion or $150,000 Singapore per company for the company to compose their initial ESG reporting. So this is a gesture that we think it's a very important gesture, suggesting that the Singaporean authorities already understand that if a company wants to comply to the ESG standards, it needs, or it will cost them a lot of money. Therefore, the grant is very important. And it's more important when we think about what Indonesia gives as an incentive, because Indonesia is only giving like awards, like certificates or something, and it's not appetizing for business. Because I have spent, for example, $1 million to comply with the ESG standards. Why would I only care for the certificates or awards? So it's not appetizing in our perspectives. And then with regards to the CSR obligation or CSR funding, Indonesia, there is a provision in the Indonesian regulation saying that a company can shift their CSR funding to do their ESG funding, to fund their ESG programs, which is, we think that it is a bit of a mixture, that they don't understand what are the differences between CSR and ESG. And it becomes very confusing because in Indonesia, CSR is mandatory for certain types of companies. It's a very unique aspect of Indonesia, because I think in other countries, most of other countries does not regulate CSR as something mandatory. It's a voluntary gestures of the company. Next, please. And then we are also looking at Japan's approach with regards to ESG regulations. These are the regulations in Japan. There is a stewardship code, there is a corporate governance code, and etc. Next, please. And we also look at the subjects, and we found that in Indonesia, in Japan, and in Singapore, they are obliging listed companies under the supervision of the financial services authorities. It is only Singapore that expands or plan to expand their subjects into non-listed companies with a certain threshold. And then with regards to incentive, while Singapore provides incentive or grants, Japan is more of providing this incentive, because if you don't comply to the ESG reporting standard, then there will be like fine or penalties given by the authorities. And then also with regards to CSR obligations, there is no such regulation as in Indonesia, where you can shift your CSR funding to the ESG funding, because once again, the CSR in Singapore and Japan is more or less voluntary instead of mandatory. Next, please. So here we are comparing the regulations and the perspective of what are CSR and ESG in Indonesia, Singapore, and Japan, and we think that there is a very different approach that Indonesia has because it mandates CSR to be mandatory in Indonesia. And next will be explained by my colleague.
Good afternoon, everyone. Please allow me to continue the presentation of our paper. So I would like to discuss about some critiques of the Indonesia ESG legislation. First of all, that the Indonesian ESG legislation is lacking of unified or unification because in Indonesia we only has the first ESG regulation is on the regulation on OJK 2017, and it is also only applied for particular companies in Indonesia, for example, for the public company, listed company, and also some companies in the financial sectors. And it is also incomprehensive framework with regard to the ESG regulation because other than the ESG regulation, which is recognized under the POJK regulation, we also recognize the company law 2007, which is regulating about the CSR. And according to this company act or company law, the CSR is obliged for a particular company which is dealing with the natural resources field or areas. And we also found that the regulation on the ESG is also having a kind of disharmony because we recognize the ESG regulation for particular types of companies, but then we also recognize the CSR regulation under the company law. And next, with regard to the particular ESG legislation in Indonesia, this POJK regulation is having a limited scope, as our colleagues already mentioned, that it is only obliged for the public companies and also companies in the financial sectors. So it is not covering, let's say, the companies which is not, which is having activities outside these sectors. And with regard to the CSR regulation in Indonesia, it is also several disharmony and also several limitation of the CSR obligation because some of companies which is not having activities in the natural resources management, they are not obliged to implement the CSR obligation. And with regard to this comparison that we undertaken by comparing Indonesian ESG regulation with that of the Singapore and Japan's, we found here that there are some comparisons here with regard to the unification of regulation. So we don't have one and comprehensive regulation on the ESG, while on the other hand, Singapore and Japan, they have more unity of the regulation for some companies. And then the other difference is that in Singapore and Japan, they already adopted and harmonized with the international standard, while the Indonesian ESG regulation, we do not provide which standard that companies must follow. So it is also giving such confusion for the companies how to implement the standard of in the implementation of ESG in Indonesia. And then with regard to the one among other principle in the ESG regulation, with regard to the CSR, that in Indonesia, CSR is mandatory, while in Singapore and also in Japan, it is kind of voluntary for the companies. And then for the commitment that must be undertaken by companies in Indonesia, we found that in Indonesia, ESG obligation is more limited on the particular kind of companies, for example, public company, financial sectors company, etc. And we also provide some discussion and also recommendation with regard to the improvement of ESG regulation in Indonesia, that the government need to do some collaboration and cooperation with other countries, especially in ASEAN. And also we need to consider about harmonizing the ESG standard in Indonesia with the international standard. And in conclusion, with regard to the ESG regulatory framework in Indonesia, we also propose some recommendation. First of all, that we need to improve the ESG regulatory framework to be enacting and integrated with other sectors, so not only financial sectors, but also the other relevant sectors. And then we also recommend that the ESG obligation to provide disclosure and a report is not only limited for the public company or listed company and financial sectors company, but also should be implemented for the other relevant companies. And then next recommendation, that the ESG reporting standard should be aligned with the international standard, which is already recognized and also adopted by any other countries in the world. And the last one, that we need to improve the cooperation and also collaboration with the regional neighbor countries and also the global level, in the global level, to improve the implementation and also the regulatory framework of ESG in Indonesia. So I think that's all our presentation. So I would like to hand over the times to Professor Yetty as the chair of this session. Thank you very much.
Thank you very much. Can we give a round of applause to the presenters? Thank you. Now I give the floor to Professor Chen to give your comments.
Thanks very much. The paper by Professors Laurensia, Irna, and Dina addresses a topical issue and is timely research resonating with the growing interest in sustainability in the ASEAN region. As they've mentioned, the ASEAN region is an acronym for the Association of Southeast Asian Nations. So it was fascinating to read the author's insights drawn from a comparative analysis of Indonesia's framework vis-a-vis Singapore and Japan. And I understand that one of the key aims is to facilitate Indonesia's progress towards achieving the Sustainable Development Goals. And it envisages drawing from other countries as well in Asia. So I wondered if it might be useful to look at neighboring countries, and being Malaysian, I thought I might share some insights from there. One of the challenges raised in the paper is the lack of understanding of ESG, and it cites the Indonesian Chamber of Commerce statistics that only 35% of businesses in Indonesia understand ESG principles. And I wondered if perhaps in Malaysia some of the capacity building initiatives might be useful. So for example, we've got the Joint Committee for Climate Change, known as JC3. And this is collaboration of financial regulators and key industry players. And they run really practical workshops, things like helping companies to understand how to report, just giving them case studies, reporting tools, and finance at a competitive rate as well, because it does cost. So they help listed companies to prepare sustainability reports, but more broadly, they also work with like small and medium enterprises to build capacity, to help them to report on their greenhouse gas emissions across the supply chains. They bring them together in roundtables to talk about challenges with policymakers, with people who provide solutions. So they then explore challenges and opportunities to equip them with the practical tools to achieve this reporting and to translate aspirations towards better ESG into practice. So reporting, but also finding solutions that are more sustainable to what they're currently doing. I guess that also takes us to another question. We've got rules that talk about ESG reporting with the view to promoting better ESG in practice. But how really do we translate law in the books to law in practice? And I wondered if there were other strategies as well that could be adopted. So when I thought about some of the other existing shareholder or corporate governance mechanisms, what came to mind was a paper by Lloyd Freeburn and Professor Ian Ramsey about shareholder activism in Australia. So at that time, Australia didn't have mandatory reporting rules for listed companies, but they looked at how shareholders went to the AGM and they would put forward shareholder resolutions on climate. And they then looked at it empirically and found that these sorts of measures, these shareholder resolutions, this activism at the general meeting helped to promote better climate governance in the companies. So that could be other mechanisms as well that complement the disclosure requirements. And by way of background, I think with Australia and the shareholder activism, there are environmental groups that actively buy shares and then go to the AGM and put forward shareholder resolutions. So it's quite targeted. But it does, I guess, demonstrate that shareholder resolutions and the AGM can be a complementary mechanism to help promote better uptake of ESG within a company. I also thought of institutional investors as a potential way of being able to help to promote better ESG. I think Prof. Yetty would know a lot more, having done a paper recently about institutional investors in Indonesia and stewardship codes. In Malaysia, institutional investors that are government-linked have a particular mandate, and they're required to act more for the public benefit, but I'll get back to that a bit later. So one of the suggestions that the authors raise is expanding the disclosure requirements, perhaps to more companies beyond listed companies and beyond financial services companies. And they looked at, say, businesses that are generally governed under the Companies Act and the SOE Act. I wondered if it might be worth delving into some of the nuances of expanding disclosure requirements. For example, would it be more compelling to require, say, larger companies with more resources and perhaps a larger impact on the environment to disclose, perhaps, as opposed to maybe a very small family-owned company that doesn't have much resources. Maybe they're just making ends meet and don't have much environmental impact. So it might be worth thinking about the different types of companies and perhaps what might be more compelling. So it might be more justifiable perhaps to impose these requirements on some companies, but may not achieve as much perhaps with some others. And then I think also about the point of state-owned companies, I think that's an interesting one. And in Malaysia, for example, it's certainly not exemplary, as you know, but they are regarded as being the ultimate woke company in that they exist for the public benefit. So they're supposed to then give back to the public. And back in 2006, almost 20 years ago, when ESG wasn't as popular in the West, Malaysia issued a silver book for government-linked companies and institutional investors, saying that really government-linked companies should lead corporate Malaysia as socially responsible citizens. They should proactively contribute to society, and therefore they should help with societal problems and the environment. It wasn't a silver bullet, so as you know, 1MDB and the scandal occurred through state-owned companies. So there's been good that's achieved, but there are also many gaps that need to be dealt with, and I think the lack of transparency in government-linked companies is a bit of a problem, and there's much work to be done still. And I'd be very interested to learn about how Indonesia deals with this sort of risk of scandals through state-owned companies. But in conclusion, this is an interesting article and has implications not only for Indonesia, but the broader ASEAN region. So Indonesia is really important as the largest economy in ASEAN. But the ASEAN member states are also thought to learn from each other, or anticipated that they will learn from the other more advanced member states as part of the economic blueprint. So I think the research that you're doing has real potential to improve what's happening in your country, but also in the broader region. And I look forward to seeing your article published and to its impact that it will have on the region. So thank you for sharing your research, and all the very best.
Thank you. Thank you, Professor Chen, for the, I think, constructive feedbacks. Yeah. Now we still have like 10 minutes then. So I invite the floors, and perhaps I may ask colleagues from Japan and Singapore, because this is touch upon your jurisdictions. So it might be helpful for them to have your view as well. Okay, thank you. Any other? Okay, one. And then, of course, okay. Yeah.
So I'm not from Japan or Korea, but I was going to, or Singapore, but I was going to ask, you mentioned that there's no financial incentive, but there's like an award. But in the past, reputational gains were to be had by being recognized in these sort of best-in-class lists. Are companies in Indonesia not actually thinking of this as a reputational gain because now there's like a mandatory rule, everyone has to do it? Or is it your view that this is not a good enough incentive?
Okay, thank you for your question. First of all, this is based on our analysis, so we are not doing empirical work yet. So it's not based on the company's perspective that they don't really want, to gain reputation. But once I was invited to a company, and then they asked with regards to the ESG regulations, and so they ask really what kinds of benefits that they will get if they do this ESG reporting. And then I'll say, well, if you're asking me from the perspective of legislations, I would say that in this article, this regulates that you will have, actually there are 2 benefits or 3 optional benefits. The first one, you will get training, like how to prepare the ESG or how to comply with the ESG regulations for your employees, for the company employees. And then the second one is that you will get, an award, such kind of, gaining a reputation. And then third, it says other benefits. So it's not specified in the regulations. It was already in 2017, the regulation, but it was not specified until now what kind of other, incentives that are given by for the companies. So yeah, that would be from our understanding. Thank you.
Yeah, thank you very much. I enjoyed the paper, and of course, comparing Singapore and Japan is of interest to me. I guess just though pushing back, or at least trying to get a bit more information on one of the points that you made. when you brought up the issue of mandatory CSR, right? I think that's a very interesting point. But immediately it made me think of India and how India has mandatory CSR for large companies for 2% of profits to be applied to CSR. And in the Indian context, right, I don't know if Arja will agree with me, but I look at this as just a sort of a bit of a sad admission by the government that it feels that companies can fulfill or can dispense a tax essentially better than the government can, right? If you apply this to everyone, right, then what you're saying is, they could have added 2% to the corporate tax rate, in which case the money would have went back to the government to deal with the collective action problems. But they don't do that. They say, try to fix these yourself with the 2%, right? So in Indonesia, right, if you think about CSR, and if I understood your paper and slide correctly, this applies to natural resources, right? And again, I don't know the details of this, so I'd just like to hear more. But my thinking is Indonesia, of course, has massive natural resources, right? And I'm sure there must be a lot of difficulties with environmental issues, labor issues, whatever. And is this a strategy for the government to essentially do what India did and say, well, the government hasn't handled this in many aspects properly, and so we're delegating this now to companies. And who are those companies, right? Are these Indonesian companies? Or I would find it even more interesting if these were international mining companies in that, because that would be quite fascinating to me. If they're international companies, then you're actually sort of applying some sort of tax, and maybe you're saying international companies can carry this out better than the Indonesian government, and that could also be an interesting tool. So it just sort of, that occurred to me. So I was wondering, how, if that is maybe one justification, maybe not that they didn't understand the difference, but that this is sort of strategic regulatory design, for lack of better words. And the second point is, I love that you're comparing within Asia and Singapore and Japan, but should it work the same in Indonesia, right? I think Singapore, and maybe I won't get any praise when I fly back to Singapore for saying this, but I'm sure Singapore is happy that it's on the slide as a model because it would love this. But for Indonesia, Singapore is 6 million people, Indonesia is 280 million people. The levels of development are at different stages, and so does it make sense to look to Singapore or Japan, or would it maybe make more sense to look to India? And to say, what has India done, to draw on Aurelio's presentation from earlier, to look to another place in the global south for a lesson, rather than diverting immediately to the hyper-developed part of Asia. And so I just wonder whether that also, I'm not saying, again, maybe to echo Aurelio again, I'm not saying that India is perfect. I think actually I don't agree with the system, but they've had over a decade to deal with it, right? And so it may be worth an examination to say, where have they went right, where have they went wrong? I know India's tweaked the provision, as I understand, in how they enforce and whether it's mandatory. So that's very interesting. Now, I don't say cut out Japan and Singapore, but maybe. It would be interesting to say, well, how has India dealt with it since you have mandatory and it's there, and India's had this for a long time, and it's 1.4 billion people. That could be interesting. So I'm just wondering whether you've looked at sort of developing Asia and particularly the Indian example. I may be totally wrong on this, but there seem to be some parallel there. Yeah.
You would like to respond?
Okay, so first of all, thank you very much for the suggestion, and we will consider to accommodate the feedback and suggestion for improving our paper. But why we choose Japan and Singapore, the consideration, if we regard that Japan and Singapore already recognize and also adopting the international standard, while in Indonesia there is no standard that is suggested or that is governed by the government to be implemented by the companies in Indonesia. That's why, as we already said earlier, that some of companies in Indonesia, they confused which standard that they should follow. So that is one of the consideration, and maybe my colleague will add some explanation.
Thank you, Professor. I think your background on and also the suggestion to put India as our one of our comparative study, I think is very logic. Yeah, probably we, Professor from India, do you have like probably one or two sentence? Is it now still happening in India that CSR is mandatory?
Yeah, CSR is still very much mandatory in India. It has been since 2013. Another jurisdiction you could look at is possibly Denmark.
Denmark.
Yeah, Denmark
also
made
mandatory.
CSR mandatory, I think, in 2008.
Yeah.
And it's again not all companies. It's only certain companies in Denmark.
Okay.
But I'd be very interested to take a look at take a closer look at the Indonesian law and how it compares. Maybe ACLF 2026.
Yeah,
right?
Probably we can see deeper about the reasoning why, and how India and also Denmark implementing this kind of a concept that CSR is mandatory, because this is not probably not dominant in the world, because all other jurisdiction they have like voluntary in concept of the CSR. Okay, I think it's a good idea to looking at India and Denmark. Yeah, thank you for the suggestions. Yeah.
Thank you. Is there any other questions? Yeah.
It's not a question. I just wanted to add. The reason I was even asking about the incentives there was because once we had the mandatory CSR requirement in India, the spend actually went down. There's empirical studies that I can point you to show that now it's not a matter of reputational gain anymore, right? You're just complying with the law. And I saw a resonance in that when you said they were asking for what other benefits can we get. So people aren't saying, hey, this company is doing so well, but they're saying, oh, this company is not complying with the law. So maybe that's something I can point you to, that research. Thank you.
Thank you.
Okay, thank you. Because of the time, the limited time, but can I ask just one sentence then before just to give you a historical background of our mandatory corporate social responsibility, which is Article 74 in our company law. It is as a result of compromise at that time, because we are having the new law number 40/2007, and there is this one provisions, and this one provisions is asked by the member of parliamentary at that time, because of the situations in Indonesia that there is huge environmental damages at that time. So they said, okay, we are going to enact this law if Article 74 is included. So this is actually a compromise. Why then we have this mandatory CSR that is different with any other jurisdictions? Okay. Again, thank you so much for the wonderful discussions. And with this, I end up our sessions. And thank you, and see you in the next session. Thank you.